Hello and welcome. You're watching To The Point. Yaqub Memon was hanged at 7 o'clock this morning, but he leaves behind critical questions hanging in the air. Does the Supreme Court err by not enforcing its own guidelines that require a minimum of 14 days between the rejection of a mercy petition and the execution of a death sentence? Did President Mukherjee dispose of the mercy petition with what some people consider unwarranted haste? And finally, has this whole episode converted a hanging into a tamasha? Those are the key issues that I shall put in a moment to the Attorney General of India, Mukul Rohatgi. But first, a recap of the key developments over the last few days.
1993 Mumbai blasts convict Yaqub Memon's 21-year-old effort to escape from guilt ended last night. Yaqub Memon's last day saw a series of setbacks, beginning with the Maharashtra governor rejecting his plea for clemency. And this setback was followed by the three-judge Supreme Court bench refusing to stop Memon's hanging. Another mercy plea filed with the president was also rejected after discussions with the Home Ministry. But Memon's lawyers made one last-ditch effort. And in an unprecedented development, a hearing was held in the top court's premises in the middle of the night. But Yaqub's lawyers failed to impress the Supreme Court again, and Yaqub's fate was sealed.
I am very disappointed and unhappy because I think the Supreme Court has made a tragic mistake.
If you delay by 3 days, 5 days, then what happens is, it's not as if there's any teary hurry in that sense. Of course you can delay it by a few days. But then there has to be some finality somewhere.
Meanwhile, back at the Nagpur Central Jail, Yaqub, who was keeping tabs on all developments with a hint of optimism, gave into despair. Spoke to his daughter and asked his brothers to look after his family. As night gave way amid tight security, both outside Nagpur Jail and his Mahim residence, his execution was carried out and he was declared dead at 7:01 in the morning.
The hanging of 1993 Mumbai blast convict Yaqub Memon has left the society across social strata with polarized opinion. While one section says and hails the hanging as a testimony to justice being delivered, many question whether hanging or capital punishment can ever be part of the judicial system or the concept of justice. What goes down the memory lane is the overnight drama at the Supreme Court, the midnight hearing, and the deeply polarized opinions that he leaves us with. With camera person Vishal, this is Anusha Soni for India Today.
Welcome back. I'm now joined by the Attorney General of India, Mukul Rohatgi, to address some of the disturbing questions the last 24 hours have raised. Attorney General, Yaqub Memon was hanged today, roughly 9 hours after his last mercy petition was disposed of by the President. Was this not a clear breach of the Supreme Court's guidelines announced just 18 months ago in January 2014 in the Shatrughan Chauhan case, which clearly stipulate that a minimum period of 14 days is needed between the rejection of the mercy petition and the execution of a death sentence?
Karan, the first thing is that the first petition for presidential clemency was rejected on 11th of April 2014. From that day, if you calculate, it is more than 14 months.
Can I come in at that point? You see, that first petition, that you referred to was in fact moved by his brother. The petition that I'm referring to, which was moved yesterday, is the only petition moved by Yaqub Memon himself. Surely this petition, because it's his own petition, has much greater meaning and validity, and the 14-day stipulation should surely attach and apply to this. not refer to the earlier one?
Well, I don't think that is correct, because if you see the facts, the brother moved the petition on behalf of Yaqub. It was meant for Yaqub, and what really happened was the very next day, Yaqub wrote a letter to the superintendent jail pointing out that his brother had moved a petition for clemency to the president and notice must be taken thereof. So it was as good as his own petition. That's number one. But the law recognizes that successive petitions can be filed. So let's proceed on that basis. Now, if you have a cut-off date of 30th of July and you move a petition on 30th July in the morning, and then you say that another 14 days must be given after the rejection of the petition filed on the day, the fateful day, then 14 days will start from today, and then on the 13th day you could again make a petition and say now it must be considered either by the governor or by the president, and you will have a self-perpetuation of 14 days.
Except
that is not the spirit of the law.
Except for the fact, Mr. Rohatgi, no one for a moment is arguing that the 14-day stipulation should apply to every single mercy petition that is moved. I'm not saying that. I don't believe Yaqub Memmon's lawyers were suggesting it either. The point being made is this, that there is a material, significant and very important difference between a petition moved on your behalf by your brother or a family member and a petition that you move yourself personally. There's that personal involvement, there's that personal effort being made by a condemned man asking personally for mercy. That's why the 14-day stipulation should apply to the one he moves himself, and that wasn't done.
Now, see, Karan, you have to understand, firstly, I don't think that there is any difference in a petition being moved by the brother and endorsed by Yaqub or one moved by him. But even then, if one has to see that a successive petition can be moved by the convict, can you move it on the eve of a date which was fixed on 30th of April? The date was not fixed yesterday. It was fixed 3 months in advance. And you must also see the entire picture. And I must recount a couple of dates for you to see the entire picture. The blast took place in 93. The conviction is recorded in 2007 after 14 years. Sentencing the convict to death. An appeal is filed in the Supreme Court. The Supreme Court deliberated at great length. The judgment runs into hundreds of pages. It bisects everything. All evidence is discerned and sifted by the court, and judgment is delivered in March 2013. Thereafter, a review petition is filed, which is rejected. Thereafter, the first attempt at presidential clemency, which is rejected in April 14. Thereafter, a second review petition, which is dismissed on 9th of April 15. Thereafter, a curative petition filed in May and dismissed on 21st of July. Thereafter, 2 petitions to the governor on 22nd and 28th of July. Thereafter, a new writ petition filed on 27th of July, which is heard on 3 days and dismissed at 4:30 yesterday. And thereafter, lastly, a petition for clemency filed before the president at about 2 or 3 o'clock in the afternoon.
Let me now respond.
And the date was known on 30th of July.
Let me now respond, Attorney General. Your mastery of detail would be truly convincing rather than just an attempt to blind the audience with detail if for one fact that you've overlooked. That in fact Yaqub Memon deliberately and perhaps consciously waited for the entire legal process to finish with the curative petition before he moved his mercy petition, first with the governor and then with the president. What's wrong in waiting for the entire legal process to finish before you move the mercy petitions? There's a real logic behind that. That may be the logic behind his waiting till that moment. You're overlooking that possibility in the details you're trying to blind the audience with.
I am not overlooking at all. The legal position is that a mercy plea can be moved at any time.
Precisely.
And having chosen to move it through his brother on 11th of April 2014, you must understand that some time or the other some finality has to come. If 22 years is not good enough for a finality, then I don't know when you will have some finality.
Well, finality seems to be terribly important to lawyers and to prosecutors, but to the rest of us, what is so sacrosanct about hanging Yaqub Memon on the 30th of July? Would heavens have fallen if he was hanged instead on the 13th of August or the 14th of August? In other words, would the Indian state have come crashing down if one condemned man was given 14 days as Supreme Court stipulated guidelines themselves require? That's what I'm questioning. What would have happened if those 14 days were granted?
Well, obviously nothing would have happened if 5 or 10 days would have gone by. But you have to stick to some timelines. Justice is also to be done to the other side. Don't forget that this gentleman was convicted of killing 257 people. So you can't have a self-perpetuation that I will create a situation by which I must get 14 days knowing that a date was fixed 3 months ago. And in any case, the Supreme Court has ruled twice in the last 24 hours that this is not the legal position. They have explained the judgment you are talking about, namely Shatrughan Chauhan, and I think a quietus must be put after 2 judgments of the Supreme Court in the last 24 hours on this very issue.
You know, the Supreme Court's explanation is only the final explanation because the Supreme Court is the final stage. It's not necessarily right for that reason, it's just final. And I'm going to put this to you. What the other side wants is justice, not revenge. That is why the Supreme Court guidelines of the Shatrughan Chauhan case stipulate that a 14-day requirement is needed for 3 particular reasons. 1, to give the condemned man an opportunity to prepare himself mentally. Secondly, to make his peace with God. Thirdly, for a last and final meeting with his family. By denying him those 14 days, that was overlooked.
I don't think it is overlooked. It is mentioned in the judgment if you care to read the last 2 judgments. But the point is, at which point of time will the 14 days start? If it starts when you decide it starts, when a date is staring you in the face, or you decide when you had moved a representation in April 2014, what was stopping the prisoner from challenging the rejection by the president? Nothing stopping him. He could have challenged it by saying the president didn't apply his mind. He was using both the forums, the legal forum, and I have told you there were several attempts in the legal forum.
Okay.
In midway he moved the executive forum, and well, I mean, you have to have some finality. I mean, you can't say that another 5 years, 10 years can go on.
Well, no one's talking of 5, 10 years.
Don't come to an end in
Mr.
14
Rohatgi,
days.
be fair, no one's talking of 5, 10 years. And one other point, no one is now saying that Yaqub Memon shouldn't hang. Even those who moved the petition are willing to accept that hang he will. All they're saying is that the Supreme Court guidelines require that he be given those 14 days, live up to the Supreme Court's own commitments. And secondly, they're saying this is something that we owe a human being as a human being, regardless of what horrible crime he's guilty of. And since the world would not have changed and heavens wouldn't have fallen, grant him those 14 days, hang him on the 13th or 14th of August. The Indian state wouldn't be diminished by that act of humanity, it would be strengthened.
This argument was raised before the Supreme Court. The Supreme Court has considered the guidelines you are referring to, and the Supreme Court came to the conclusion that there was nothing wrong with the death warrant which was issued on 30th of April. That's it.
All right, I accept that. Let's then move to a second aspect that is also a troubling question today. It's the fact that the President handled and heard and disposed of the last mercy petition in something like 7 hours flat. According to press reports, he received that last petition yesterday afternoon at 3 in the afternoon. He disposed of it, as I believe you yourself said, at 2:45 in the morning by 10 p.m. That's exactly 7 hours. And my question is simple and straightforward. Should a mercy petition be decided in just 7 hours? Is that haste not unbecoming?
Well, if somebody decides things promptly, you accuse him of unholy haste. If things are procrastinated, you then accuse the person of long delays. Now here, look at the situation. Actually speaking, the date was fixed on 30th April, as I said. If the President and the Supreme Court at 4 o'clock in the afternoon did not upset the death warrant. The Supreme Court said, go ahead with the death warrant, which is slated for 7 o'clock in the morning. And then, during the course of the hearing, the President receives it at 3 p.m. If he examines it between 3 p.m. and 8 p.m., then what is wrong?
Well,
because you can't say that the Supreme Court will not interfere with the death warrant, and by an indirect method, you move a petition at the last minute and then say willy-nilly the President should grant a stay on the death warrant and extend the date, which the Supreme Court did not choose to do at 4:30 in the afternoon.
Attorney General, you rhetorically asked the question, what is wrong? Let me answer that question directly. Promptness is a virtue probably in all instances. Sure. But I'm not sure promptness is a virtue when you're handling a condemned man's mercy petition and the outcome could be his death. And I'll tell you why in this specific instance it's not a virtue. Because this mercy petition that was given to the President at 3 in the afternoon raised two matters that everyone says the President had not been made aware of previously. First of all, it raised Mr. B. Raman's claim that there were mitigating circumstances that could have been and possibly should have been considered at the time of sentencing but were not, because the court was not aware of them. And secondly, it raised the question of the schizophrenia from which Yaqub Memon is said to be suffering at the moment. Those are two new issues. And I put it to you, surely they required more than just 7 hours for the President to seriously consider before he disposed of them.
Let me answer it, Karan. Let me answer it. The last point first. The issue of schizophrenia has been raised time over again, which is reflected in the judgment of the Supreme Court in 2013 itself. So it is not new. Number two, on what basis are you assuming that the President of India and the Home Ministry, which is meant to aid and advise the President, did not look at all the features and give their aid and advice, and the President thereafter acted upon it? The President is not an appellate authority. He doesn't have to read 300 pages of a judgment as if the Supreme Court judgment is impugned before him. He has already rejected it once. He will go through it. He will go through the aid and advice of the Home Ministry and come to a conclusion whether a case deserves mercy or not.
Can I interrupt?
This is his job and this is what he has done.
Can I interrupt? Part of your answer, at least, is based upon the fact that you believe that some of the issues raised in the mercy petition were part of the record and had been considered by the President or by those who advise the President. But in fact, Ujjwal Nikam, the original prosecutor in this case, said to this very program in so many words that the mitigating circumstances claimed by B. Raman were neither known to Ujjwal Nikam, and then he added very specifically, therefore they had not been made known to the court at the time of the original sentencing. Therefore, when you turned around and say that everything was known to the President and considered by the President, Ujjwal Nikam himself is contradicting you.
No, I only talked about, I'm sorry, I only talked about schizophrenia. I did not talk about Mr. B. Raman.
Then
now,
why?
As far as Mr. B. Raman is concerned, nobody knew of this article. Nobody knew of this article. This article is not a piece of evidence, and unless it is a part of evidence, it cannot be looked at as a plea of mercy. It has to first be proved. If it is proved, the entire case may have gone a different way.
Can I put to you what Justice Harjeet...
The President doesn't examine it.
Can I put to you what Justice Harjeet Bedi, a former judge of the Supreme Court, said on record, both to this program and to the Indian Express?
Yes.
He believes that the Supreme Court itself should have taken suo motu notice of B. Raman's article in rediff.com. The Supreme Court chose not to do that. If then that very article is raised as part of a mercy petition moved by the condemned man, surely it's incumbent on the President, both morally and also in a responsible sense, to take greater note, not to dispose of the matter in a mere succinct 7 hours flat.
Let me tell you, Mr. Bedi's article is his own view. According to me, the article which is surfacing after 25 years, which has no aspect of veracity, the writer is not available, the judgment is over, this cannot be a ground in a mercy jurisdiction at all.
All right. Let me put this to you. Some people have the clear impression from the way events were being reported yesterday evening that the President was possibly, and I use that word possibly advisedly, under pressure from the government because he had the Home Minister and the Solicitor General sitting there with him in Rashtrapati Bhavan as if they were anxiously pressing, if not coercing him for a quick decision. How can you convince the people of India that that impression is mistaken?
Well, I don't think there is any reason to doubt the Honorable President, and I don't think the Solicitor General was there. In fact, the President had called me for the reason that the judgment delivered at 4:30 had not been uploaded till about 9:30. So he sent for me and asked me what were the basic contents of the judgment. Thereafter, between him and the ministry, the advice was given to him and he considered is a matter between him and the ministry.
You know, the second impression that's been left with people is to do with that adage, which you know perhaps as a lawyer better than I do, that justice must not only be done, it must be seen to be done. Now, when Yaqub Memon's own personal mercy petition, raising what his lawyers believe are two new points that previously were not raised, and even though you dispute the schizophrenia being new, clearly the B. Raman contentions are new, and when all of that is disposed of in 7 hours flat, for many people this raises questions that worry them. And I'm talking not of people who are Yaqub supporters, I'm talking of people who simply don't like what looks like judicial shortcuts. And it seems as if a process has been slightly shortcutted for no good reason.
A jurisdiction of mercy under Article 72 of the Constitution does not have the parameters of a legal appellate jurisdiction. And I may inform you that the Supreme Court also disposes of murder appeals or appeals of heinous offences in much less time. So don't expect the President to become an appellate judge over the Supreme Court and then start examining it. It's entirely a different jurisdiction. It is based on some features of the case, the broad features of the case. The President had examined it in the first instance. He obviously examined the fresh petition which was moved, and I dare say there is no reason to accuse the President of having it, done it in 6 or 7 hours. Probably it could have been much earlier.
I'm not accusing the President, I'm simply pointing out an impression that's been left in people's mind, and I'm asking you to respond on behalf of the President as the Attorney General.
Well, I think it is, Karan, I think it is an accusation to tell the first citizen of the country that in a matter of hanging, where he has dealt with scores of mercy petitions in the past, that, well, 7 hours is not good enough for a person to go through a few documents to see what should be done or not.
Sir, he is the first citizen of the country and a most respected first citizen of the country. Nothing that I would say in any way would delegate that. But it is also the right in a democracy for any citizen to question the President, particularly in the performance of his task, particularly on an issue where the lawyers concerned themselves to raise that problem. But let's move on. I was simply asking questions. I want to clarify, I wasn't accusing the President, but yes, I was certainly asking questions and certainly strenuously asking whether 7 hours is sufficient to decide a mercy petition. But you may be right in arguing it is. Let me come to my final issue. It's one simple question. For many people, it's a rather worrying situation, or impression rather, that's been created in the last 5-6 days, when the hanging seems to be the outcome, A, of setting what people consider artificial and controversial deadlines, and then secondly, as a result of appeals that many think were unnecessarily rushed. And people say that what's happened is that a hanging, which should be a solemn, somber moment of deep reflection, has been converted instead into some sort of tamasha. Does it worry you that this last 5-6 days has been more like a tamasha and spectacle than a serious judicial hanging?
I don't think so, Karan, at all. And I must tell you, the Supreme Court has been extremely indulgent. The Supreme Court has heard petition after petition. The first petition was heard, as I told you, on Monday, Tuesday, and yesterday from 10:30 to 4. The 3-judge bench did nothing else, and it heard and finally decided. The Supreme Court rose to the occasion when another last-ditch effort was made, and I can quite understand an effort by a condemned prisoner. There is nothing wrong in that. The Supreme Court rose to the occasion. The Chief Justice nominated the bench. The judges were woken up at 2 a.m. in the morning. They rushed to the Supreme Court. I was woken up at 2:30. I rushed to the Supreme Court. A full hearing was given, and there has been a complete access to justice in the last 22 years to any ordinary person, including a condemned person, and I think everybody must salute the Supreme Court and the manner in which it gave a free access and free run for all aspects of the petition. Nothing was disposed of on a technicality, and matter was heard with great patience. And if you feel that this is also rushed, then I guess that it should take about 30 or 40 years for any death sentence to be executed, keeping in view that death sentences are few or far between. It is the rarest of rare, and as you know, more than 50 or 70% of death punishments are commuted to life by the Supreme Court, either because of tardiness in the system of delays or in the tardiness of disposal of the mercy petitions. So if you have death penalty, then well, this is an example where there has been complete access to justice, and I think justice has been done to all concerned in this case, and I have no feeling or any doubt whatsoever in this regard.
Mr. Rohatgi, I am particularly grateful to you for having accepted this invitation, for having agreed to face up to these questions, for having answered them so fully, and for many, I will admit, also very reassuringly, because I think in a democracy it's important that not just issues that please those who rule us should be raised, but also those questions should be raised that sometimes may be awkward for the Supreme Court or the government to have to face. Answering them, and you have done it very well today, is also something that journalists are required to enforce as part of their duty. My thanks to you once again for joining us on this particular show tonight.
Thank you, good night.
Good night, Mr. Rohatgi.
Good night.